Okay, let's get started. Once again, welcome, and thanks for joining today's session, How Inheritance Advances Have Grown to Become an Important Part of the Probate Process, a webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. Mark will address questions after the presentation. If your question is case-specific and confidential, please indicate that in the chat, and someone will respond separately after the presentation. Our presenter today is a professional with extensive experience in the probate field. Marc Harris is an attorney admitted to the Florida Bar in Southern District of Florida. Marc is also a member of the Florida Bar's Real Property, Probate, and Trust Law section. Marc has been working in the specialty finance industry for over 25 years and involved in purchasing over $100 million worth of assets. So most of the purchases pursuant to various state laws require court hearings, many of which Marc has either attended or appeared as counsel. As the CEO of ProbateCash, Marc is now spearheading a vibrant company that specializes in purchasing interest in actively pending inheritance claims from estates or trusts. Okay, so now without further ado, let's hear from Marc. Marc, I know now a lot of people have heard of inheritance advances, but can you start us off with what ProbateCash does?
Yes, and thank you, Molly, and good afternoon to everyone. Thanks for attending our webinar/infomercial. I hope this is informative to everybody here. I know we have attorneys, paralegals, and I think some realtors also here, so from around the country. ProbateCash provides advances to beneficiaries of estates who are waiting for their inheritance that's tied up in probate. I've spent much of my career providing liquidity to people who are entitled to future cash flows, but don't have the ability to access that cash flow at the present time. As most everyone on this webinar can probably attest to, and have likely fielded repeated phone calls from frustrated heirs, access to inheritances fall neatly into such a category. So people familiar with probate probably believe, like a whole bunch of lay people, what they've seen on TV. Loved ones or not so loved ones pass away. Next, the family gathers in the lawyer's office for the reading of the will. Oftentimes there's not a will. The happy family members here, they're getting mansions and money, while the jaded people walk away with usually nothing. Case closed. Here's what most people don't know and often learn right before calling your office for help, or your realtor's office, wherever you are. I can't access the decedent's bank account after they go to the bank to try to get the decedent's money, or I can't sell the decedent's property or other assets. Then they learn from you what probate is and how long it takes. Suddenly, reality rears its ugly head. Property taxes have to be paid, repairs made, bills are coming in, and beneficiaries who are counting on their inheritance to meet obligations suddenly cannot do so for quite a while. That's the void ProbateCash fills. We provide a portion of the heir's inheritance with a non-recourse upfront advance and wait until the estate assets can be distributed before being repaid.
Okay, so now, but how does an advance from ProbateCash actually work?
Okay, so a lot of people find us just by searching Google, right? The Google search terms, and they find us, or others get referred to us by lawyers and other heirs. We can talk directly to the beneficiary, but we always want to talk to the attorney representing the estate. We don't like surprises. We have the heirs complete a simple application form about who they are and the estate, and then we can often fund the advance within 1 to 2 business days after that. We have underwriters who review the case file, and then after we talk to you, we'll confirm some estate information, and we're usually ready to go. The goal of an advance is to provide some necessary liquidity to a beneficiary while still keeping that beneficiary engaged in seeing the probate case closed. As such, we don't purchase the entire inheritance. So in fact, depending on the status of the probate case, we may only purchase a small portion of the inheritance. For example, if the claims period hasn't expired or there's litigation going on in the estate, we may just provide a modest advance. If the case is a final distribution, however, and we know what the heir will be receiving, we may make a much larger advance at that time. Our average advance amount is probably under $15,000, but we've done advances as small as $5,000 and well over $500,000.
Wow, and you mentioned funding the advance in 1 to 2 business days. How can ProbateCash fund an advance so quickly?
Sure, so I explained a little bit about what we do, but let me explain quickly what ProbateCash does not do. We're not a lender, which is why we can fund advances quickly. We don't charge an interest rate, we don't do a credit check, we don't take collateral. Moreover, if the heir cannot repay the advance due to an insufficient inheritance, we will be shortchanged. That's our risk. If a will is challenged, our risk. If a creditor wipes out the inheritance, our risk. The only time we have recourse is if the beneficiary materially benefits our contract, commits fraud, or gets paid their inheritance and just doesn't pay us back. That's called stealing.
And now, in research, I read that there's ProbateCash has over 450 five-star reviews. There must be countless stories of how you've helped real people. Could you give us some real-life examples of how ProbateCash has helped their clients?
Sure, and I'm not going to bore people by we save folks from this or that. People need money as for needs that you would think people need money for. That could be paying their rent. These are beneficiaries paying rent, tuition for their kids, schools, whatever the normal issues are when you're expecting an inheritance and you learn that you're not going to be able to access that inheritance for many, many months, if not years. For real importantly, the advances have been used by executors of the estates to pay taxes on the home that are, say, the house estate property from foreclosure, or to fix up the house, renovate the house for sale so the house can fetch fair market value. Those are really important things that benefit all the beneficiaries. Usually the executor is a beneficiary as well. An advance to beneficiaries also takes some of the pressure off of executors who are looking to sell the home but want to get fair market value. The executor, as you guys know, or all, like you guys, are probably receiving phone calls from the other beneficiaries. Why does this take so long? And that puts a lot of pressure on everybody, and having a lot of pressure can lead to decisions that aren't really in the best interest of the estate. We do have more than 450 five-star reviews, and that really goes to a credit to our people. We provide excellent customer service and quick funding. We do what we say. And we also talk very highly of the estate attorneys. As Molly mentioned, I'm an attorney. My wife's also an attorney. We talk very highly of lawyers when there are delays. We know why there are delays. It's not y'all. It's the probate courts. It's the process. It's just generally that's how probate works. And so we also, after we make an advance to a beneficiary, we stay in touch with the heirs. And so they call us now sometimes to get updates on what's going on with the estates. We give them general status reports, whether the creditor claims period is ended, or where we stand, so they have some kind of idea. So that's why we're really proud of those five-star reviews, and we encourage you to take a look or send potential clients to them.
Okay, and now circling back to the title of this webinar, how do you think inheritance advances became an important part of the probate process?
Well, I remember when this was a pretty new field, and it was like, wow, you can make advances. How do you do that against the inheritance? And now that it's become more mainstream, I should say, it's become a part of the advance, because now lawyers, executors, folks know that we exist. And so when beneficiaries really need money and they're calling the executors, they can refer the beneficiaries to our company for a quick advance. It's also, because it's mainstream, we're pretty good at quickly underwriting the case, stay in touch with the estate attorney, not to bug the estate attorney, not to nag the estate attorney, just to keep everybody in the loop. And that's really become a norm now. And depending upon where you live, and where there's more probates done because of certain laws, like if you're a California attorney, you probably know this exists. If you're a realtor in California, you probably know it exists. Elsewhere, maybe not.
And how does an advance to one beneficiary affect other beneficiaries who are not assigning portions of their inheritance? And also, how does the advance affect the probate case?
Okay, so that's good and very important for the folks on this call who have to worry about fiduciary duties owed to creditors to the beneficiaries. When we make an advance to a beneficiary, we go into contract with that beneficiary. We're not under contract with any folks who are not receiving the advance. If the executor is not receiving the advance, we're not under contract with the executor. We're not asking the attorney to provide representations and warranties. So it's just that interest of the beneficiary. If that turns out the beneficiary's inheritance is insufficient to repay us in full, that goes back to the non-recourse part of it. We do not look to the other non-assigning beneficiaries to get repaid. And we're not a creditor to the estate. So that's also important. So it doesn't affect the probate case at all. What we do, though, however, is we will file the assignment of the inheritance in the probate court. For example, if somebody is assigning $20,000 of her inheritance, we'll file that assignment document in the probate court just to give everybody a heads up that this is there. We want the personal representative to pay us out of the estate, not out of these estate assets, but the beneficiary share of the estate assets, the person who assigned their inheritance to us. And just want to make sure everybody's on board. As said, the only time this business gets a little nuts is if somebody didn't realize our assignment and we're caught off guard at the end of the process. So we try to avoid that. And even to that case, to that point, before we advance money, before we send out the money to our customer, we also do a recorded phone call with that customer and make sure they understand how much they're receiving, how much they have to pay back. And we just go over everything on a recorded call, so there's no confusion.
Okay, but can now multiple beneficiaries get an advance from ProbateCash?
Sure, and often do once one beneficiary receives money from us and then spreads the word. Other beneficiaries sometimes follow, sometimes not. It doesn't matter if they do or not, but we do provide advances to more than one beneficiary of an estate.
And now, are there any laws that govern inheritance advances?
There are. So there are a couple. And if you, as I mentioned, California, there's a probate statute in the probate code. It's 11604.5. So California 11604.5. Utah has a fairly new law that's the same as the California statute, or substantially the same, and that is the probate code 75-3-918. And as you can imagine, both of those statutes are very consumer protection oriented. We're required to put disclaimers in the contract. We're required to make sure that the heir understands the terms. That the court always has the option of, in their review of the assignment, inquiring about the assignment and making sure that the court is okay with it or not. And that's the California and Utah laws. When we do business in just about every state in the country, and what we do is we follow the California statute in spirit by basically the same kind of contract and filing the inheritance assignment in the court. So we like the statute, we like the transparency, and we like no surprises.
Okay, great. Mark, wow, we've already reached that 15-minute mark, and I've peeked over the Q&A, and we have quite a bit of questions, so I want to make sure we get to them. So as promised, Mark is going to stay on to answer those questions, but if you need to leave now, we'll send everyone a link to the recording and the questions and answers. Also, if you have questions you'd rather ask offline, you can call Mark at 561-476-0018 or email him at marc, and that's MARC, at ProbateCash.com. So let's get to your questions. First one is, I represent a plaintiff who is challenging their heirship. Do you make advances into adverse cases?
Okay, that's a good question. And the answer is yes. We have been doing that now for the past couple of years. So even if the heirship is not clear, we will take a look at the case. If it's a plaintiff case, we usually want the plaintiff's counsel to be on a contingency fee. We want to have you guys in the same boat as us, or at least motivated to see this through. But we will make advances to the plaintiff or defendant, and that should carry them through the litigation and take some of the pressure off. So I think people have seen, you may have heard of pre-settlement litigation for torts usually that take place. This is kind of the probate version of that, and we will make advances in those situations in the right circumstances.
And then if the next question is about referrals. If they send a referral to you, what's the process? Go to your website or?
You can go to our website. You can always call me directly and email me directly. We also take care of folks, especially when they're referred to by counsel. So we have our own dedicated phone line from lawyers who call in or referrals of lawyers who call in. That's, in fact, I will get you that number. I think I have that. And that number is it's 561-616-6124. 561-616-6124. And that's how we know it's an attorney referral. And that's not that we treat people differently, of course, but we certainly care about our lawyers. That's and I'm always open to talking as well. The one thing also that we're talking about challenges of heirship or referrals. Sometimes we'll make an advance for the purpose of opening up the probate. So if you guys are using your marketing dollars and you're out there and the potential heir and executor has Googled you, wants to hire you, but has no money, we may make an advance to that anticipated beneficiary and executor for the purpose of paying your attorney's fees. What we're looking for in those situations is that the estate has real property that's going to be sold. So that's in a lot of our cases, as you can imagine, there's not a lot of liquid assets. There's usually real property. That takes time to get sold, renovated, and get cleared up with taxes. The usual things in a house sale, but a little bit more complicated because it's probate. So that's what we're looking at, the sale of the property to usually be the proceeds to repay inheritance assignments to us. So if you're getting those folks and you don't want to lose them and you want to explore whether or not we can make an advance to a potential client of yours, that's all I really ask is to find out a little bit about the real estate and whether it's going to be sold that would be an estate asset or homestead.
Awesome. Great. And now I think we have 7 more questions, so I'm going to try to speed through them for you, Mark, because I know everyone has to get back to things. One thing, someone mentioned CLE credits. Unfortunately, we can't provide those. Not yet, at least, but maybe one day. But the next question is there an interest charged on the cash advance?
All right. First of all, I just listened to about 30 hours of CLE tapes, so I wish we could get this. I haven't really inquired to see about getting these approved for CLEs, but I also like to keep everybody's attention, so we don't like to go too much over 15 minutes. These are not interest rates. Remember, these are not loans. So there's no rate, no due date where some certain amount of payment must be made against the advance. We are purchasing a portion of the inheritance. We charge fees, and the fees are around 25% of the advance amount is where they usually start at, and they can go up. This is not inexpensive money. This is, I encourage people to use our services when they have financial necessities to meet. I would not use our services to take an advance to take the family to Disney World or go to a World Cup match.
Great. And the next question was about the fee, and you already covered that. So you were reading this person's mind.
The fees do go up, so it depends on. Yeah. We usually cap them. But we always cap them because sometimes these can go out for well over a year, 2 years, 3 years. But they start at 25%. Now, here's where it comes in. If I'm talking to you guys as probate attorneys and I am able to feel better that these are non-recourse, so there's sometimes they don't go the way we want them to go. If I feel more comfortable, our company feels more comfortable that we're going to get repaid, then that we can adjust the fees accordingly. So, we'll make modifications to help out.
Are there any limitations of the estate size or jurisdiction or case type?
No. We'll do intestate cases with a will. The only state we're not doing business in right now is in Virginia. I think in Connecticut, the minimum advance has to be at least $50,000. So no small advances in Connecticut due to a little bizarre a law, not even in the probate code section. But otherwise, we can do advances just about everywhere else in the country. California and Utah have the actual code to follow, which makes life a lot easier for everybody. And that code, I say it makes life easier for everybody, maybe not so much for the attorneys who have to, and required by the probate code to include us in the petition and final order for distribution when we're at money.
And the next is, what percentage of an expected inheritance can typically be advanced? I know you said you do all types.
Yeah, so what we're looking at is, again, what stage is the probate case in? So if let's have an example of somebody's going to be receiving $200,000 inheritance, anticipated $200,000 inheritance. Now, we're going to assume that they're going to be costs and expenses. So we have a proprietary model that we look at, and we immediately will put a little bit of a haircut on that $200,000. If the case is just petition filed or in the claims period, we're going to assume that claims could be made against the estate. Or if it's really early on, that heirship may not be totally agreed upon. So there could be some kind of surprise. So that could be a modest one. As the case continues to move through the courts, we can make large.
I think Mark might have froze there. I think is he back?
I can hear you. We just had a power outage in our building.
I wasn't sure who it was, if it was you or I, and that's the benefit of a live TV, right? So,
yeah, that's pretty wild. And it's not, I'm in South Florida, where usually at this time we get some storms to give a power outage, but I don't know what it is today, but.
Well, if we want to, we have two more questions we can run through, just the audio, and then, like I said, we'll be sending the recording to everybody else. But as long as
that $200,000 example, on something like that, the maximum advance that we would probably provide in that situation at any given time would be somewhere around $50,000 to $75,000. We do want to keep them engaged, to the beneficiary engaged, to actually receive money when the estate assets are to be distributed.
And it's funny you mentioned South Florida, because the next question is Florida specific. It's like, what if there's only real estate property in Florida in the estate? How does that work?
Okay, we will do those transactions, and I'm assuming that question's asked because of the Florida's homestead law, which is not unique. There's some other states that have a homestead law too. If the property is going to be homesteaded, I'll still work with the estate attorney and the heir to make an advance, and basically against the proceeds from that home being sold. So same kind of analogy. The home we have to know the home's going to be sold. If somebody's living in the home, that they're moving out, they have real plans to move out, and in that situation, we'll proceed with that advance and wait until the property is sold to get repaid. Hopefully, what we want is you guys as attorneys to be working with them through the sale of the homestead property. The business fails to work for us if our actual customer at the end of the day usually receives their inheritance. Sometimes at that point they forget to pay us back. So we like to be paid back through the personal representative to write the check to us, or from the attorney, or if it's in a blocked account, in a state account, something of that nature.
Okay, and I think it's our final question. It says, how long does it usually take from application to funding?
That can take as little as hours, or 1 to 2 business days. It depends on the case. If you're coming to me with a adverse litigation case that's requires some work. That could be a while. That could be a week or two to go through, which really is not a while when you compare it to other ways to obtain a loan or other sources of financing. So we have a company of 30 employees here in-house, and a lot of those are underwriters who are able to open up the file, have a phone call conversation with you. They speak probate language and understand the issues. They're issue spotters. And in some states also, ProbateCash, as you can imagine, has its own counsel for, as a CEO and an attorney. That means I'm hardly an attorney anymore. And so I like to send some stuff out for more knowledgeable people to take a look at. If it's a little complex, and that could take a day or so. But in our business, we know time is everything, and the people who need money now usually need it now. They need it immediately.
Great. Well, I think now we've got to everyone's questions. I want to thank everyone for all those excellent questions. Those were awesome. And if you're like me, though, and if you think of something after the fact, we will be sending up a follow-up email with a link to this webinar, and you could ask, you can call Marc at any time, and you can call Marc at 561-476-0018, or you can email him. And again, that's Marc, MARC, at probatecash.com. So thank you again for joining us, and thank you for the questions, and have a great day.